I'd like to welcome everyone to the hearing today. The meeting is called to order at 9:30 a.m. Today's proceedings are being held as a hybrid meeting by way of in-person attendance and teleconference to hear minor variance applications PLMV 2025-027, PLMV 2025-087, and PLMV 2026-001. The Committee of Adjustment is appointed by Council to consider applications for minor variances to the zoning bylaw pursuant to Section 45 of the Planning Act. A minor variance may be granted provided it meets the four tests, namely that the variance meets the general intent of the official plan and zoning bylaw, that it is minor in nature, and that it is desirable for the appropriate development or use of the land, building, or structure. The Planning Act requires that a public hearing be held. The public hearing serves two purposes. First, to present the Committee of Adjustment and public the details of the application, and second, to receive comments from the public and agencies before a decision is made. All submissions form part of the public record. Both the Secretary Treasurer and myself will be responsible to ensure that all parties and the committee members can hear one another during the hearing. For those attending by teleconference, if at any time you have difficulties hearing what is being said, please say so or click the raise hand button or dial *9. We kindly ask that everyone speak slowly and clearly when addressing the committee. If you are of the opinion that holding the hearing as an electronic hearing is likely to cause significant prejudice, we ask that you advise this committee at the earliest opportunity and the matter can be addressed accordingly. Any applicant or agent that is in attendance at today's meeting for a specific application may leave the meeting once their application has been considered by the committee. Any applicant, agent, or member of the public wishing to address the committee for a specific application is reminded that the presentations are limited to 10 minutes per person. If you are using a computer or electronic device, please ensure that your microphone is turned on and your audio settings are not muted. All parties are verbally acknowledged before being asked to proceed. At this time, I would ask that anyone who objects to an electronic hearing of a matter on today's agenda or is having difficulty hearing what is being said, please click the raise hand button or dial *9. All right. The committee will first adopt the agenda. Would the Secretary Treasurer please read the resolution?
Through you, Mr. Chair, moved by Paul Radals and seconded by Honoree Tall, be it resolved that the Committee of Adjustment hereby approves the agenda of the February 23rd, 2026 meeting as circulated.
All those in favor? It's carried. Do any committee members have a pecuniary interest in the applications being heard today? Good to go. There are minutes to approve from the November 24th of 2025 meeting. Does the committee have any comments or questions about those minutes as circulated? Would Secretary Treasurer please read the resolution?
Through you, Mr. Chair, moved by John Aggett and seconded by Jean Neville, be it resolved that the Committee of Adjustment hereby approves the meeting minutes of November 24th, 2025 as circulated.
All those in favor? It's carried. I now declare this to be a public hearing of application PLMV 2025-027, located in Part Lot 28, Concession 7, Geographic Township of Minden, 1062 Renown Drive on Sawyers Lake. Would the Secretary Treasurer please summarize the proposed variance and any correspondence received to date regarding this application?
Through you, Mr. Chair. So this application was submitted by property owners Jason and Laura Miller. The property comprises an area of approximately 0.5 acres with frontage of approximately 102 feet on Sawyers Lake and is developed with a dwelling and accessory structures. So I will just note that the attachments don't appear on the agenda the way that I had referenced them in the report. So I apologize for that, and I will try to clarify that as I'm reading through my notes on the application. So attachment number 1, as referred to in the report, is the original site plan that was included, however, I believe is attachment number 3 in the agenda. This illustrates that the property was occupied by a detached deck for a hot tub, a shed, and decks attached to and beneath a portion of the shed. The property owners have since removed the hot tub deck, and the shed and portions of the attached decks were also removed with the intent of reconstruction, but previously had reduced setbacks to the shoreline, as well as reduced side yard setback of 10.1 feet at the rear of those structures. Attachment number 2 is the existing site plan, and that did get included as attachment number 2 to the agenda. This illustrates the partial reconstruction of the deck that has already taken place. The subject application is specific to the new deck intended to be attached to and supporting the proposed shed. I did want to note the application form indicated that the former decks were 296 square feet. However, it looks to be somewhat of a calculation error. Based on the original site plan and photos provided with the application, it looks as though the original deck was about 208.68 square feet. And so inclusive, and that would include the portion that was underneath the shed. The application has therefore been assessed on the former deck's size being the 208.68 square feet. The new deck, which can be seen on the existing site plan, has a slightly improved setback to the shoreline of 30.3 feet. However, portions of the new deck did further reduce the side yard setback contrary to the zoning bylaw. So staff have confirmed that there's no support for that reduction, and that portion of the deck will have to be removed and will form a requirement of approval of this application. In further discussions with the property owners and based on the application, an additional section of approximately 18 square feet is being proposed added to the northeast side of the existing deck. This will serve to square off the deck, and but it will continue to exceed the minimum side yard setback of 15 feet. The proposed site plan, noted as attachment number 3 in the report, but it's attachment number 5 in the agenda, identifies the intended footprint of the deck. The portion highlighted in green is to be removed, and the portion highlighted in yellow is a proposed addition. Following reconfiguration, the total ground floor area of the deck would be approximately 294 square feet. The expanded footprint of the deck does not comply to the zoning bylaw and requires minor variance. The subject property is zoned shoreline residential. A detached deck is permitted as a shoreline structure, but it must comply with the side yard setbacks. The deck as a standalone structure is considered non-compliant given the reduced easterly side yard setback. However, under the zoning bylaw, the future intent of that deck is to be attached to and supporting the proposed shed, and that changes the provisions relevant to the decks as it would be considered to form part of the shed. So to ensure complete compliance with the deck, recognizing the shed as a future build, I did provide variances to capture the deck both in its current state as a detached deck, but then also in its future intended state as being attached to and supporting a shed. So as submitted, the application requires the following relief from the zoning bylaw. From section 4.8.4, subsection 4, to permit reconstruction and expansion of a non-compliant deck having a ground floor area of 294 square feet, which represents an increase size of 40.87%, whereas otherwise the maximum increase is 25%. And from section 4.8.4, subsection 6, to permit a non-compliant deck having being attached to a shed and having a maximum total ground floor area of 294 square feet, inclusive of the portion beneath the shed, representing again an increase size of 40.87%, whereas otherwise no increase size is permitted. As well from section 4.9.1 to permit development on an existing undersized lot where additional relief from the zoning bylaw is required. So the 4 tests of a minor variance were assessed for the application as follows. Is the application minor in nature? So the new deck would be 85.3 square feet larger than the previous deck. However, a significant portion of that expansion is going to be under the permitted shed. And so the actual total developed footprint increase will only be 30.25 square feet. If you include the removal of the hot tub deck, then overall the development within the shoreline area is reduced. And so the application is considered to be minor in nature. Is the application desirable for the appropriate development or use of land, building, or structure? The application will enable the reconstruction of previously existing structures while providing greater foundational support to the shed, as well as greater safer access, and will maintain existing deficient setbacks. The application is therefore found to be desirable for the appropriate development or use of the land and building. Does the application uphold the general intent and purpose of the official plan? The subject property is designated waterfront on Schedule A. Sawyer's Lake is also recognized as being moderately sensitive. Permitted uses in the waterfront designation include recreation-based residential uses and accessory structures. The development will have no impact on septic capacity and is not expected to impact runoff to the lake given the previous existing development. The official plan does not specifically contemplate types of shoreline structures, but directs that clearing should be restricted, and the extent of shoreline structures should be limited. As the deck is over a previous developed area, no further site alteration is required, and the deck is also not further contributing to the maximum cumulative width of shoreline structures. Therefore, the application is considered to uphold the general direction and purpose of the official plan. Last test, does the application uphold the general intent and purpose of the zoning bylaw? The subject property is zoned shoreline residential on Schedule 8. Limitations regulated through Section 4.8.4 for non-complying structures is intended to ensure that potentially incompatible or problematic land uses are not aggravated, as well as to prevent overdevelopment. As mentioned, existing setbacks will be maintained or improved through the proposed development. Lot coverage remains compliant for the accessory structures and would not impact the maximum cumulative width as previously mentioned. And as well, most of the deck expansion will be underneath the shed, which is a permitted reconstruction. Given this information, the application is considered to uphold the general intent and purpose of the zoning bylaw. The application is also required to be consistent with the provincial planning statement. Under the PPS, the subject property is part of the rural area, more specifically rural lands. Permitted uses include recreational dwellings and associated accessory structures. So the application is consistent with the policies of the PPS. We did not receive any comments in relation to this application, either from members of the public or agencies. Based on the assessment of the application, it appears to meet the core test and is consistent with the policies of the PPS. And therefore, it's recommended that application PLMV 2025-027 be approved subject to the conditions that are outlined in the report.
Thank you. Is the applicant or property owner here today? Or would you please, you're welcome to sit at the table there. Make your comments. Thank you. If you would state your name and then make any comments about your application.
Laura Miller, no comments.
Okay, that was simple. Are there any members of the public who would like to speak to this application? We will start with anyone attending electronically. Oh, we have no one that way. All right. Is there anyone attending in person who wish to speak to the application? Seem to be. Are there any questions or comments from the committee to the applicants, the planner, or any persons who have made presentation? Yes.
Is it appropriate for my asking who their builder is? My son does a lot of work in Sawyer's Lake, and I have no idea where they build. So I want to make sure.
Sure, absolutely.
Conflict
Oh,
of
good-
interest.
Good point.
Myself and another carpenter friend.
Good.
Perfect. Right, clean.
Yeah.
Are there any other questions or comments from the committee? Yes, Paul.
I guess my comment was when I went out and measured and looked at it, it looked really tight in there. So I'm really happy that we've put in the condition about the land surveyor. You know, because when I look at the green line you put down there,
Yeah.
it sure doesn't look like 8 and 12 feet.
Right.
Right, so it was just a comment, it wasn't. a
Sure,
question.
no, it's good, fair comment. Are there any other comments? All right. If there are no further comments from the committee to the applicants, could the committee make comments about reasons why the application may or may not be supported for the purposes of this decision? Yes. Any comments, Paul?
I think because it's a small lot that, you know, how do you say this? It's uniform to how all the other lots are, like all the building is close to the side lots anyways, and so it's not a change to, that part of Sawyer's
Right.
Lake where everything is close together.
The comment that I would share is that in the net, it seems to improve a lot. All right. If there are no further comments, would the Secretary Treasurer please read the proposed conditions of the minor variance?
Okay, just go to that page. Um, So the recommendations are, not dissimilar to what we would typically see. The first being that the minor variance is only applicable to the deck, and that it shall comply with all other applicable law. The second being just that the, construction will be in accordance with the, site plan that is part of this report, which is inclusive of, removing the portion of the deck that is currently non-complying with the zoning bylaw, and as well making sure that the setback at the rear of the structure is only 10.1 feet. That an Ontario Land Surveyor shall confirm those setbacks to the satisfaction of the township, and that if a building permit is required for the deck, which might be just given some of the elevation change to the deck, that they would apply for that. We have changed it. Normally, our condition does say 12 months. We've said within 6 months, just because the deck has already been partially reconstructed. And that way, we're moving that up in the timeline. And then the last being our typical failing any part of those conditions, that the application would be refused and the deck would have to be removed from the property.
All right. Are there any questions or comments from the committee regarding these conditions? My comment would be that 6 months from today is basically the end of August. Hearing all the evidence before it, the committee ready to make a decision? Okay, with the Secretary Treasurer, please. Let's move slowly.
Yeah, you might want to draw that out a little bit. I
Okay.
just need a second to,
Hearing all the evidence before it, is the committee ready to make a decision? All right. Oh,
I'm almost there.
thank you. Please bear with us while we maneuver through the procedures. Yes, talk amongst yourself.
I'm ready.
Would the Secretary Treasurer please read the resolution?
Through you, Mr. Chair, moved by John Agate and seconded by Paul Radals, whereas the Committee of Adjustment considered the written and oral submissions relating to application PLMV 2025-027 Miller made at the hearing, and whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area, and is minor in nature, and more specifically for the following reasons: that there appears to be no issue with the neighboring properties, the development is uniform and similar to surrounding lots, and that the development would improve the lot. Now therefore, it is the decision of the committee that application PLMV 2025-027 requesting relief from the requirements of bylaw 06-10 as amended to permit the following: from section 4.8.4 subsection 4 to permit reconstruction expansion of a non-compliant deck having a ground floor area of 27.3 square meters, 294 square feet, representing an increased size of 40.87%, whereas otherwise a maximum increase of 25% is permitted. From section 4.8.4 subsection 6 to permit a non-compliant deck attached to a shed having a maximum ground floor area of 27.3 square meters, 294 square feet, inclusive of the portion beneath the shed, representing an increased size of 40.87%, whereas otherwise no increased size is permitted. From section 4.9.1 to permit development on an existing undersized lot where additional relief from the zoning bylaw is required. Subject to the following conditions: that approval of the minor variance shall only relate to the proposed deck, having a total ground floor area of 294 square feet, inclusive of the portion to support the future shed, construction of which shall comply with all other applicable law. That construction shall proceed substantially in accordance with the site and building plan submitted to the township on February 10th, 2026, and put before the committee on February 23rd, 2026. And forming part of this decision, inclusive of removing the portion of the deck identified in green on the proposed site plan being approximately 35 square feet and resulting in a shed setback of 10.1 feet at the southeast corner of both the deck and future shed. That an Ontario land surveyor shall confirm the setbacks in accordance with the approved site plan to the satisfaction of the township. That should a building permit be required by the chief building official for the deck, that the permit, which is to remain in good standing, be applied for within 6 months of the approval of this application, following submission to the building department of the appropriate application fees and supporting information as required by the chief building official, and that failing any part of the foregoing conditions, this application shall be deemed to be refused and the deck shall be removed from the property.
All those in favor? That is carried. I now declare this matter to be concluded. Good luck. All right. I now declare this to be a public hearing for application PLMV 2025087, located in Part Lot 8, Concession 1, Geographic Township of Anson, 1169 Trellis Trail on Bob Lake. Would the planner please summarize the proposed variance and any correspondence to date regarding this application?
Thank you, Mr. Chair, and good morning, committee. Through the chair, the application was submitted by Dave Roberts on behalf of himself and Pamela England as property owners. The property comprises an area of approximately 1.3 acres with frontage of approximately 63.6 meters on Bob Lake. As per the application, the property is currently developed with a 69.7 square meter, one-story dwelling with an attached covered porch and open deck. As proposed, the owners wish to construct a new two-story detached garage having a ground floor area of 56.95 square meters or 616 square feet. The main floor of the garage is intended to provide for vehicle parking, and the second story is proposed for storage only. The proposed garage would be located 25.29 meters or 83 feet from the shoreline of Bob Lake, and it's proposed to have a mean height of 6 meters or 19.7 feet. The application requires the following relief from the township zoning bylaw from section 4.1.6 to permit a height of 6 meters for a detached two-story garage being set back 25.29 meters from the high water mark, whereas a maximum height of 3.5 meters is otherwise permitted for an accessory building within 40 meters of the high water mark. From section 5.2 to permit a setback of 25.3 meters to the high water mark, whereas otherwise a setback of 30 meters for a new detached garage would be required. The application is subject to the 4 tests of a minor variance as outlined in the Planning Act. Test number 1 is the application minor in nature. When assessing whether an application is minor in nature, the consideration must relate to the potential impacts of the variance requested. Mature vegetation along the shoreline directly in front of the garage site has been maintained in a natural state and serves to visually buffer the existing and proposed development from the lake. The garage is permitted in the location proposed, and the relief is specifically for the height of the building. As proposed, there are no concerns with respect to stormwater or drainage, and there is no increase in septic capacity as a result of the development. The application is therefore found to be minor in nature. Test 2 is the application desirable for the appropriate development or use of the land, building, or structure. The application will enable the expanded use of the property for shoreline residential uses, and the proposed use is consistent with permitted uses and development in the surrounding area. Based on information from the owners and as confirmed during a staff site visit, the area for the proposed garage requires minimal tree removal. Previous tree removal in the area during 2025 mainly included damaged and fallen trees. Challenging topographical constraints on the property limit the available lands for building. An increased shoreline setback is not possible due to the presence of a rocky and extreme vertical elevation change at the rear half of the property. The proposed location of the garage will be further from the shoreline than the existing dwelling. In addition to visual screening provided by the vegetation along the shoreline, the significant elevation change to the rear of the property will make the garage appear less vertically imposing. The application is therefore found to be desirable for the appropriate development or use of the land, building, or structure. Test 3, does the application uphold the general intent and purpose of the official plan? The subject property is designated waterfront on Schedule A in the township's official plan, with Bob Lake being recognized at capacity. Properties located at capacity lakes retain existing development rights, which include permitted accessory uses. To achieve the preservation of natural shorelines and maintenance of character, the official plan promotes a 30-meter setback of new development in the waterfront area. As mentioned before, the proposed two-story garage is physically unable to meet this setback due to the rocky and steep inclined elevation of the property. The shoreline will remain undisturbed, and the maintenance of the existing shoreline vegetation helps to prevent shoreline erosion, which is essential for protecting water quality entering lakes as a result of the water runoff. The maintained vegetation along the shoreline with the steep elevation behind the new garage will also give the visual perception of a smaller building that will blend into the natural landscape, further mitigating the visual impacts of the proposed building. The application is considered to uphold the general direction and purpose of the official plan. Test 4, does the application uphold the general intent and purpose of the zoning bylaw? The subject property is zoned shoreline residential on Schedule 10 of the zoning bylaw. Section 4.1.6 requires a maximum of 3.5 meters for accessory buildings or structures located within 40 meters of the high water mark. The purpose of the provision is to maintain visual integrity from the water and balance between natural and built form. A garage is a permitted use on the property, and as proposed, a second-story storage area would have a usable area of 56.9 square meters. The property already benefits from a sleeping cabin, and therefore, in accordance with section 4.1.2, the township zoning bylaw, the upper story of the garage is required to be used for storage only, and no habitable use is permitted within the building. The proposed garage will be located further from the high water mark than the existing development on surrounding properties and exceeds the required setback of 23 meters for lots created prior to February 22nd, 2005. Aside from the height, all other development standards would comply with the zoning bylaw, inclusive of total and accessory lot coverage. The application is considered to uphold the general intent and purpose of the zoning bylaw. The application is also required to be consistent with the provincial planning statement, PPS. Under the policies of the PPS, the subject property is considered rural lands. Permitted uses on rural lands include resource-based recreational uses such as recreational dwellings and associated accessory uses that maintain the rural character and can be sustained by rural service levels. The application does not conflict with the policies of the PPS. Notice of this application was circulated to neighboring owners and commenting agencies in accordance with the statutory requirements of the Planning Act on February 13th, 2026. There have been 2 letters of support received for this property from adjacent landowners that was circulated and further provided in hard copy for your review. No further comments have been received from members of the public agencies. The application appears to meet the 4 tests of a minor variance and is consistent with the policies of the PPS. Therefore, it is recommended that application PLMV 2025087 be approved, subject to the conditions identified in the report.
Thank you. Is the applicant or property owner here today?
Yes, I am. Dave Roberts is here.
Okay. Would you please make your comments to us?
Yeah, sure. First, I'd like to thank Jody and Amanda from your planning department. They've been a big help in this whole process. I would say my wife and I purchased the cottage back in 2016. And then subsequently in 2018, we purchased the adjacent spare lot between myself and neighbor with the intent of subdividing it and adding it to our property. So we, one idea was to prevent another cottage from being built close to us and taking a building lot off the lake, which helps its at capacity status. But one of the things I further justified the purchase on was it would permit me space down the road to build this garage, which we're here today to listen about. So I think that's my only real comment.
All right, well, thank you for sharing that with us. Are there any members of the public who would like to speak to this application? We'll start with anyone attending electronically. No one else? All right. Is there anyone attending in person who wishes to speak to this application? Are there any questions or comments from the committee to the applicants, the planner, or any persons who have made presentations?
I guess I have one here. It's Dave. One of the conditions is that Ontario Land Surveyor confirms the setbacks. Is that a condition I have to bring in a surveyor and have that completed? Is that my understanding, or is it just unclear on that?
Hi, yeah, so one of the conditions is to confirm the setback of the proposed garage. So an Ontario Land Surveyor will have to visit the site to pin and confirm that 83-foot setback from the high water mark.
Does that have to be completed before this is permitted? Like, do I have to, I just order of operations here to get to plans, designs updated and the permit done? I'm just curious.
Typically, yes, as a condition of the minor variance, this would be a requirement prior to a building permit.
Oh, okay. They come out in the winter, I hope.
Question for the planner. It's an educational question. Section 4.113A2, the sleeping cabin designation for the upper floor of a garage. I thought in most cases that two-story garages were limited to 35 square meters. So it's an educational.
No, and fair enough. There were housekeeping bylaw amendments for section 4.1.13 sleeping cabins. So the wording does not explicitly require the second level to be a sleeping cabin. So therefore it would be permitted to be used as storage.
Okay, so previous builds that I have been on, it was deemed by the building department that you had to have it less than 35, but as a sleeping cabin.
Less than 30, yeah, 35 meters squared, and that's specific for a sleeping cabin. So
Right.
a storage area would not be considered a sleeping cabin.
So if it was finished but didn't have any plumbing or electricity, and is that still deemed a sleeping cabin? Like, you see what, like I see this as storage and I've seen other ones.
So
They finished the upstairs, but they're not using it for.
So through the chair, through the report, it has been confirmed with the property owners that the upper floor will be an unfinished space, which would not promote a habitable space and be used only for storage.
But once you finish it, then it would apply then.
If it was proposed to be a finished space, it would depend on what is submitted and
Okay.
each would.
No, I'm just trying to understand.
Yeah, and sorry, through the chair, just to maybe clarify, there isn't anything in the zoning bylaw that requires us to consider the upper story of a garage always to be a sleeping cabin. We do look for certain design elements to ensure that if there is already a sleeping cabin on the property or that it wouldn't comply with those sleeping cabin provisions, that it would not lend itself to that, and that is why in this case, it's noted as being unfinished.
Amanda, follow up on property first question. You say it's not uncommon variances for land surveyors required to.
Through you, Mr. Chair, it is a fairly standard condition. Often because what is being requested is a reduction to a setback. And so we want to ensure that what is being requested as a setback is properly measured. And that can only be legally and accurately completed by an Ontario land surveyor.
And so the building department and the CBO would be familiar with that.
Correct.
Right. Are there any other further questions or comments from the committee to the applicants, the planner, or any persons with presentations? No? Comments may be also for reasons why the application may or may not be supported for the purposes of the decision. Does anyone have a comment in that regard? Yes, Chief.
Well, it appears that the application is supported by neighbors, which is positive, and the height of will not restrict.
Excellent comments. Any other comments? Anyone? Okay, all right. As there are no further comments, would the Secretary Treasurer please read the proposed conditions for the minor variance?
Through you, Mr. Chair. So the conditions, again, are very typical. The first being that the minor variance is only related to the two-story garage and again noted as being unfinished second story. The next condition being that the construction will be substantially in accordance with both the site and building plans that form part of this application. That an Ontario land surveyor shall confirm the setback to the satisfaction of the township, that a building permit is to remain in good standing and be applied for within 12 months with anything required from the building department. And lastly, that failing any of those conditions, that the application would deem to be refused.
Hearing all the evidence before it, is the committee ready to make a decision? All right. Would the Secretary Treasurer please read the resolution?
Yes, through you, Mr. Chair, moved by Paul Riddles and seconded by Honoree Tall. Whereas the Committee of Adjustment considered the written and oral submissions relating to application PLMV 2025-087 Roberts and England made at the hearing, and whereas it is the opinion of the committee that the temporary relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area, and is minor in nature, and more specifically for the following reasons: that the application is supported by the neighbors, and that the height will not restrict the view of the lake. Now therefore, it is the decision of the committee that application PLMV 2025-087 requesting relief from the requirements of bylaw 06-10 is amended to permit the following. From section 4.1.6 to permit a height of 6 meters or 19.7 feet for a detached two-story garage being set back 25.29 meters or 83 feet from the high water mark, whereas a maximum height of 3.5 meters or 11.5 feet is otherwise permitted for accessory buildings within 40 meters of the high water mark. And from section 5.2 to permit a setback of 25.3 meters or 83 feet to the high water mark, whereas otherwise a setback of 30 meters for the new detached garage would be required. Subject to the following conditions: that approval of the minor variance shall only relate to the proposed new 56.95 square meter to 616 square foot two-story garage with an unfinished second story to be used for storage only, construction of which shall comply with all other applicable law. That construction shall proceed substantially in accordance with the site and building plan submitted to the township on December 15th, 2025, revised December 19th, 2025, and put before the committee on February 23rd, 2026, and forming part of this decision. That an Ontario land surveyor shall confirm the setbacks in accordance with the approved site plan to the satisfaction of the township. That the building permit, which is to remain in good standing, be applied for within 12 months of the approval of this application, following submission to the building department of the appropriate application fees and supporting information as required by the chief building official. And that failing any part of the foregoing conditions, this application shall be deemed to be refused.
All those in favor? That is carried. I now declare this matter to be concluded. Moving on. I now declare this to be a public hearing for the application PLMV 2026001, located in Park Lot 10, Concession 2, Geographic Township of Letterworth, 1.257 Canuck Trail on Davis Lake. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application?
Thank you. And through you, Mr. Chair. The application was submitted by property owners Karen Marshall and Jackie McNeil. The property comprises an area of 0.35 acres with a frontage of approximately 23.7 meters on Davis Lake. It is noted that the property owners completed the purchase of a shore road allowance to increase compliance opportunities for the proposed development. The property is currently developed with a 90.7 square meter, one-story dwelling with an attached 28.8 square meter attached deck. According to the accompanying survey submitted with the application, the existing building and attached deck meet all required setbacks except for the north side lot line, which has a setback of 3.91 meters at the closest. The dwelling is therefore considered an existing non-complying building. Due to the shape of the lot at the rear of the property, the setback of the northwest corner increases to 4.21 meters. As proposed, the owners wish to construct a 23.78 square meter or 256 square foot, one-story addition to the existing dwelling with a 6 square meter or 64 square foot covered porch. The proposed one-story addition is intended to marry with the existing northwest corner of the dwelling. The application requires the following relief from the township zoning bylaw. From section 4.8.43, to permit an addition to a non-complying dwelling, which will increase the ground floor area 25.6%, whereas otherwise a maximum increased size for a non-complying building is 25%. From the section 4.9.1, to permit development on an existing undersized lot where additional relief from the zoning bylaw is required. The planning application is subject to the 4 tests of a minor variance as outlined in the Planning Act. Test number 1 is the application minor in nature. When assessing whether the application is minor, the consideration must relate to the potential impacts of the variance requested. It is noted that other than the northwest corner of the dwelling, the proposed addition would meet the required setbacks considered appropriate in the context of the zoning bylaw. Further, the addition would be in an area which is already partially developed and otherwise has been maintained as lawn. Therefore, no significant tree removal is anticipated to accommodate the development. Both side yards and rear yards maintain significant mature tree cover, and there are no adverse impacts to the neighboring properties anticipated. The application is therefore found to be minor in nature. Test 2 is the application desirable for the appropriate development or use of the land, building, or structure. The application will permit the construction of an addition to the existing cottage as part of recreation-based residential shoreline use, which is a permitted use and maintains consistent with the character of the surrounding area. The proposed addition would not conflict with the required setback to the high water mark and will not further reduce the established setbacks of the current development, which are similar to those of the surrounding properties. Therefore, no additional or new impacts to the site or balance of the surrounding built and natural form are anticipated. The test of appropriate and desirable development is also a consideration of the broader public and planning interests. In this case is the shoreline and water quality of Davis Lake. As the development is proposed to be central to the property and well outside the required shoreline setback, there will be no further disturbance to the sensitive shoreline area of the property, and the proposed addition is not anticipated to negatively impact the condition of the lake. The application is therefore found to be desirable for the appropriate development or use of the land, building, or structure. Test 3, does the application uphold the general intent and purpose of the official plan? The subject property is designated waterfront on Schedule A to the township's official plan, with Davis Lake being recognized as an at-capacity lake. Existing development rights are recognized on Davis Lake. The addition is proposed to be located at the rear of the dwelling, which is well outside of the 30-meter setback as per official plan guiding policy. Being as the property is an undersized lot, the official plan suggests mergings of lands to create larger parcels where possible. As mentioned prior, the property owners have already purchased the shore road allowance to increase the lot area, and the modest size of the addition is not expected to impact the balance of the built and natural form. The application is considered to uphold the general direction and purpose of the official plan. The application, test 4, does the application uphold the general intent and purpose of the zoning bylaw? The subject property is zoned shoreline residential on Schedule 18 of the zoning bylaw. The township bylaw permits the use of single detached dwellings in the SR zone, and as existing, the dwelling and deck are considered non-complying given the reduced setback to the north side lot line. The side yard setback of the proposed addition will be 4.21 meters, matching the current northwest corner of the existing dwelling. It is anticipated that only the corner of the addition adjacent to the existing building will maintain a non-complying setback. The intent of the provisions for non-complying buildings or structures is to provide flexibility for the continuation and expansion of existing non-complying uses, and to ensure where development and site alteration is proposed in proximity of the shoreline, that a balance of built and natural form is maintained. In this case, the addition is located outside of the high water mark setback, and the addition would not contribute or create a new disruption to the shoreline area. To meet full compliance, the side yard setback for the addition, a misalignment of the wall structures at the juncture of the existing and proposed development would be required. This may cause undue hardship for the property owners by requiring atypical building design and additional construction requirements. I don't have my last page here of speaking notes. So. We may just have to wing it. Yeah. Okay. The application is required to be consistent with the PPS. Under the policies of the PPS, the subject property is considered rural lands. Permitted uses on rural lands, including resource-based recreational uses such as recreational dwellings and associated accessory uses that maintain the rural character and can be sustained by rural sub-service levels. The application does not conflict with the PPS. Notice of this application was circulated to neighboring landowners and commenting agencies in accordance with the statutory requirements of the Planning Act on February 13th, 2026, and no comments have been received from public or agencies to date. The application appears to meet the 4 tests of the minor variance and is consistent with the PPS. Therefore, it is recommended that application PLMV 2026001 be approved, subject to the conditions identified in the report.
Is the applicant or property owner online? Yes. Would you
Yes,
please
we are.
name and provide any additional information you would like to present to the committee?
No, we would like to echo the prior applicant and thank Donna and Jody for all of their help getting us to this point and getting us organized.
And this is Jackie McNeil, no comment. Thank you.
Thank you. Are there any other comments? Are there any other members of the public who would like to speak to this application? There's no, and there's no one present here. Are there any questions or comments from the committee to the applicants, the planner, or any persons who have made presentation? Yes, Paul.
Just a quick question for the applicants. I noticed 3 mature trees adjacent to where the addition is going. I was just wondering if the contractor had mentioned what would happen to those because of where the roots would be going underneath the foundation most likely.
There was nothing specifically mentioned. We would be taking whatever trees we needed to take out. We would be using professional services, of course.
Okay, thank you for that. Are there any other questions from the committee to the applicants? Are there any comments that you would like to share about why this application may or may not be supported for the purposes of the decision? The comment I made, yes. Jean has a comment. Thank you. Sorry, not paying.
Well, you said you needed. It seems like a very reasonable bill to add some space to their property and to be aesthetically pleasing and give them some more area in a small small property.
Yes, I would echo that comment that it's change to the property and was within, meets the general purposes of policies. As there are no further comments, would the Secretary Treasurer please read the proposed conditions for the minor variance?
Through you, Mr. Chair. So the first condition is just that it relates to the new proposed addition referencing the square footage and that it shall comply with all other applicable law. The second being that it would proceed substantially in accordance with the site and building plans that were submitted in December and forming part of the application and decision today. And that the building permit would be applied for within 12 months of a decision from the committee. And lastly, refusing that if any of the conditions were not completed satisfactorily, that the application would be deemed to be refused.
Are there any questions or comments from the committee regarding those conditions? Hearing all the evidence before it, no. No, hearing all the evidence before it, is the committee ready to make a decision? Would the Secretary Treasurer please read the resolution?
Through Mr. Chair, moved by G. Neville, seconded by Honoree Tall, for the Committee of Adjustment considered the written and oral submissions relating to application PLMV 2026-001, Marshall and McNeil made at the hearing. And whereas it is the opinion of the committee that the temporary relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area and is minor in nature, and more specifically for the following reasons: that it seems reasonable to add space to a small property and that it meets the general purpose of the policy. Now, therefore, it is the decision of the committee that application PLMV 2026-001 requesting relief from the requirements of bylaw 06-10 as amended to permit the following: from section 4.8.43 to permit an addition to a non-compliant dwelling, which will increase the ground floor area 25.6%, whereas otherwise the maximum increase size for non-compliant building is 25%. From section 4.9.1 to permit development on an existing undersized lot where additional relief from the zoning bylaw is required, subject to the following conditions: that approval of the minor variance shall only relate to the proposed new 23.78 square meter or 256 square foot proposed addition to be located at the rear of the dwelling, construction of which shall comply with all other applicable law. The construction shall proceed substantially in accordance with the site and building plan submitted to the township on December 15th, 2025, and put before the committee on February 23rd, 2026, and forming part of this decision. That the building permit, which is to remain in good standing, be applied for within 12 months of the approval of this application, following submission to the building department of the appropriate application, fees, and supporting information as required by the chief building official. And that failing any part of the foregoing conditions, this application shall be deemed to be refused.
Thank you. All those in favor? That is carried. I now declare this matter to be concluded. Is there any other new business to discuss today?
Through you, Mr. Chair, I have none. We don't have any applications currently, so the March 30th, meeting is canceled. And if we have any, applications for the April meeting, that would be held on, April 27th.
Will the Secretary Treasurer please resolution to adjourn?
Yes, so moved by Paul Radall, seconded by John Agate. Be it resolved that the Committee of Adjustment meeting be adjourned at 10:26 a.m. on February 23rd, 2026. The March 2006 meeting is canceled and the committee will reconvene on April 27th, 2006, providing applications have been received.
All those in favor? That is carried. Adjourned.